morning. Thank you all for joining us today. My name is Ben Rhodes. I'm the Senior Vice President for CAMS, headquartered in Charlotte, North Carolina. So thank you for all of those attending. We have people from around the two states, North and South Carolina. So Adam Beaudoin today will be giving us a presentation on architectural rules and policies during this exciting political season. We'll probably touch on some ARC and guidelines outside the political season as well. So Adam's been a practicing attorney for about 20 years, headquartered in the Wilmington, North Carolina area. Their offices are located throughout the Carolinas, or I should say North Carolina, with Raleigh, Wilmington, Greenville, and Asheville markets represented, and I probably forgot one. So Adam, I will turn it over to you if you want to share your screen, and we'll get the presentation going. We will be doing Q&A at the end of the session, so please feel free to use the Q&A button down at the bottom of the screen if you're looking to ask questions, and we will come on and read those questions at the end of the presentation and let Adam handle that for us. So thank you again for joining.
Thanks, Ben. Yeah, I'm attorney Adam Beaudoin with Ward & Smith, and I'm going to share my screen here, get this presentation rolling. Want to just remind everybody that I'm a licensed attorney in North Carolina only, so this is general legal advice regarding North Carolina. I know that there's maybe some of you from South Carolina, they're chiming in. South Carolina has fewer regulations than North Carolina does when it comes to community associations. So some of the tenets here will be helpful, but I don't want to waste anybody's time if you're hoping for specific South Carolina references when it comes to political signs and whatnot. So without any further ado, I'm going to go ahead and I'm going to start this slideshow. As Ben said, we're going to hold questions to the end. My presentation should be about 45 minutes long. I'm going to try to keep it light and entertaining. And then we'll have about 15 minutes or so for questions, which Ben will direct to me at the end. So let's hope that this works. After all, I did go to law school. I'm not a tech person. So we shall see. So when it comes to control, right, of rules and regulations within a community, I always kind of like to start kind of at the beginning. And the beginning is, what are your governing documents, right? What are you gonna look at when it comes to the priority of your governing documents, right? And at the top of the mountain is going to be your declaration, followed by your supplemental declaration, your articles, bylaws, your restrictions and rules, and this includes your ARC design guidelines, and then finally board resolutions and policies. And this doesn't matter whether you're in North Carolina or whether or not you're in South Carolina. The declaration is going to be the top of the mountain, and for the most part, that is where the authority for all your rulemaking and your ARC design guidelines are going to spring from. So when we talk in North Carolina, right, about board control over architectural review, there's two acts in North Carolina. You have the Planned Community Act, which is Chapter 47F, and you have the Condominium Act. We also in North Carolina have this thing called 47A, which is the Unit Ownership Act, but that's for condominiums that are really, really old. And unlike South Carolina has like the Horizontal Property Act. Basically what you've got is a planned community is your single family homes, typically your townhomes, and your Condominium Act is going to govern your condos, which have horizontal and vertical boundaries, right? They're little cubes of air. So the biggest thing to remember is that the board is going to have control over your architecture review and your rulemaking authority at baseline, okay? And that comes from both the North Carolina Plan Community Act, the North Carolina Condominium Act, and you'll see down here, Chapter 55A, which is the North Carolina Nonprofit Corporation Act. So we represent, I don't know, going on probably 700 or so associations throughout North Carolina. 99% of them are incorporated under the Nonprofit Corporation Act. And then there's a small percentage that are these unincorporated nonprofits. But I go to a lot of meetings and I go to a lot of membership and board meetings, and folks get angry and irritated quite often at the amount of authority that the board has, right? But that is what the state law says, right? That unless the documents specifically provide otherwise, the board of directors is going to have control over those aspects of the association. So that means unless something is carved out for the members, right? Like, for example, amendments or approval of special assessments or things like that, the board's going to make the decision by default, okay? And then we have to be very careful, because there are some communities that create either what we call an architectural control committee or an architectural review board, where the power of the board has been delegated to another committee, right? This other body that is usually appointed by the board, but it could be appointed by the developer. It just depends. It could be, in some cases, it could be elected by the membership. And so you just have to be careful about what your documents say about that. So when we talk about rulemaking authority, okay, if you don't remember anything else from this presentation, remember that typically only the rulemaking authority is only going to apply to the common areas. It's generally not going to apply over upon a lot or a unit, except in very specific circumstances, one of which we'll talk about in more detail near the end in terms of political signs, but the other one that we're going to spend a lot of time on right now, which are your architectural guidelines, right? Because architectural guidelines, by their very nature, only touch upon the actual private property of the members, right? It doesn't really govern what the association builds. It governs what the owners build or what they put on their property, right? And so there's a difference between the board's rulemaking authority when it comes to the common areas versus the ability to adopt architectural guidelines over what people can and can't do on their property. Okay, there's a big difference. Now, we have some associations that like to take some liberties with, with trying to adopt rules and regulations over the use of someone's property, right? And they'll try to say, well, you can't have more than a certain number of pets or things like that. You have to be really careful about those types of rules. And so at baseline, remember this. The board adopts rules and regulations, and those are dealing with the common areas, right? So we have a pool. The board can decide when the pool opens, when it closes for the season. It can decide whether or not to have lifeguards. It can decide the hours of operation. It can decide whether there's going to be a snack bar. They can decide whether there's going to be a lap lane, et cetera, right? But they're not going to adopt rules and regulations saying that your house can't have any Halloween decorations or can't have any holiday decorations, right? Unless the documents allow them, which generally they're not going to, right? So now we're under the Architecture Review Committee, okay? And so we have to be careful, because most of the time when we run into trouble, it's because architectural restrictions have been adopted which are inconsistent with the declaration. My example on the screen, of course, is pretty simple. It's pretty basic, right? If the declaration says that minimum square footage is 2,500, you can't up it to make it higher. You can't make it more strict or stringent, right? For example, if the declaration says that fences can be built of metal, wood, or plastic, the ARC can't adopt a rule that says, no, fences must only be wood. We'd have to amend the declaration to do that. So just something to be mindful of in terms of what kind of authority you're dealing with. And remember, architectural review, guidelines, architectural review process, it all is about one thing, which is aesthetics, right? It shouldn't be about drainage. It shouldn't be about flooding. It shouldn't be about anything else other than aesthetics, right? So the placement of the home on the lot should be from an aesthetic standpoint, not based on if it's going to annoy a neighbor or not, right? So how do we evaluate as we come down from 10,000 feet, right? We know the hierarchy of the governing documents, right? We know the declarations, top of the mountain, then we have the articles, right? Then we have the bylaws, then we've got our rules and regulations, then we've got our board resolutions. So how do we determine whether or not a rule that's been adopted or an architectural guideline that's been adopted is enforceable? This is just at baseline, right? The number one thing to always look for, is it consistent with the governing documents? I had mentioned pets previously, okay? So let's say that you want to ban pets in your community, or you want to ban a certain breed of dog. Well, a lot of associations will try to do that via rule. Well, let's look, and what do the governing documents say? So if the governing documents are silent when it comes to what kind of pets you can have, or the number of pets, or the breed of dog that you can have, if it's silent, that means the board doesn't have the authority to adopt a rule limiting what owners can do when it comes to pets. However, if the declaration were to say, the board may adopt reasonable rules and regulations regarding the number, size, breed, type, species of pet, now we have permission to go ahead and say, well, we don't want any bulldogs in the community, or we don't want any labradoodles in the community, right? Now, of course, I'm joking, because it's always pit bulls, Rottweilers, Dobermans, and some other, mixtures of those. But this is my point, right? Is you have to look to see what's in, is it consistent with the governing documents? Number two, did the association have the authority to adopt the rule or the guideline? And what do I mean by that, right? What I mean is, if you have a declaration that says the architectural review committee is the one that has authority to adopt the design guidelines, but the board tried to adopt the design guidelines, well, then that doesn't work, right? Because the board didn't have authority pursuant to the documents to adopt those design guidelines. So we have to look to see whether or not there was authority to do it, right? Number three, was the rule or the guideline properly adopted? That is, did the board vote on it? Did the ARC or the ARC vote on it properly? Did they go to the membership and get the members to agree to it if that's what the documents require? You'll be surprised how many sets of covenants I review that say the rules are not enforceable until they're published to the membership, right? That's a big gotcha, right? So anytime you want to adopt a rule, you've got to mail out or email blast or make sure that everybody's got a copy of them. And so otherwise they're not enforceable, and that can trip you up. So we want to know, number one, right, is it consistent with the governing documents? Number two, did the association have the authority to adopt it, right? And that is just like the pets, right? Could they even adopt a rule that deals with pets? Or could they adopt a rule that deals with the colors of the blinds inside the house? Or the number of political signs, for example? Was it properly adopted? Let's say they do have the authority and it is consistent with the documents. Did they adopt it properly at a duly called meeting or uniform written consent? And then finally, which is the hardest one sometimes, is, does the association have the practical ability to even enforce that rule or guideline? And what I mean by that, right, is if you don't have the ability, if you don't have an easement to go into someone's unit or to go in someone's backyard to see stuff or to figure out if people have made violations or not, then why are you adopting something that you can't enforce, right? So the practical piece of that is just really, really important to remember. And so we're going to come back to this, but just let's, as we work through it, let's just kind of remember those four things, right? The first three being, hey, do we have, is it consistent with our documents? Do we have the authority to do it? Was the process sound? But hey, should we even be doing this? So when we talk about the authority, right, to adopt the rule, it comes from the declaration, right? Whether it's a regular rule or an architectural rule. The declaration is going to say what our authority is. And so if the declaration is silent, a lot of times that means that you don't have control over it, right? So for example, in North Carolina, if your declaration doesn't say anything about political signs or the ability to regulate signs at all, we're going to have to really think hard about what, if anything, the association can do. And there are things that the association can do, but you have to be really careful about it, right? But if you, for example, don't want to allow garage screens, right? I don't know if anybody's seen these, but this seems to be the thing that's in vogue. It's like a garage door made of a screen that goes behind your regular garage door so that you can turn your garage into a screened-in porch, right? A lot of communities don't like those. But the way these screens work is they're an internal mechanism, they're not external. And so if your documents don't have the ability to control interior improvements, you might not be able to prevent it, even if you think it's unsightly or otherwise, right? So that may be a situation, and I bring this up because I had an actual client do it, where you go to the membership and you amend the governing documents to give yourselves the authority to go ahead and do that, okay? And so not all things that you want to do, right, in terms of the governing documents, just because you want to amend them doesn't mean the members will support it, but it also doesn't mean that if you are successful that it's going to be valid. Rental restrictions are a big one these days, and so you better make sure they're reasonable as well. So when we talk about how these are adopted, right, how rules are adopted, I said at the very beginning that the baseline is that the board is going to make all decisions on behalf of the association unless the documents provide otherwise. And it could be to a third party, it could be to the members. And so at baseline, it's a vote of a majority of the board to adopt a rule or regulation. Or if there's an architectural review committee, it would be a majority of that architectural review committee that would make the decision. Now we talk about this a lot. When those of you that have heard me speak, okay, I will just tell you that there is no email voting allowed for board members in North Carolina unless two things are satisfied. Number one, all the board members participate, and number two, all of them agree. And that is uniform written consent, which you see on the screen right there, okay? That's uniform written consent of the board or the ARC. So we either have a meeting where we put it on the agenda to vote on at the board level or the committee level, or we do it outside of a meeting where everyone agrees and everyone participates. And so the challenge with rulemaking, especially when it comes to ARC, right, is whose purview it's in. Is it the board's purview or is it the ARC's purview, right? And so when it comes to political signs, most of the time, it's going to be the board, not the ARC, that's going to regulate political signs. right? Because political signs are by their very nature, a temporary effect, right? They're not a permanent structure. They're not necessarily considered an improvement, right? They're like a flag or a banner or any other kind of sign, okay? And so, but we have to figure out which body is the appropriate one to adopt the rule, assuming we can do it. And then, as I've already teased this before, do you need to get approval from the members? That is, do you need to put the vote for the rules to the membership to make it effective? Or do you need to publish it to the membership to make it effective? That's going to be a case-by-case determination by your governing documents. There's nothing in state law that says that you have to do that, okay? But it happens a lot of times we find in governing documents. Now, I personally don't like it, right? Because to me, a community association is a pure form of democracy in that the members elect the board by plurality, and then the board carries out through the officers and everything else the day-to-day activities. So when you have members that are approving or giving some kind of veto right over rules and regulations, it's kind of like a Monday morning quarterback or a backseat driver. I think the members need to trust their board members, and if they don't like them, then they need to remove them or vote in new board members. That's the way I like to handle it. But there are some documents that create that check and balance, and you need to be careful. So, what is the process for approval, right? This is the kind of the third leg of this chair, right? Is there a separate ARC, or does the board function as the ARC, right? Because there are some associations where the board wears two hats, right? They wear one hat where they're board members, and then they wear another hat where they're the architectural review committee, and they might even wear another hat where they're the nominating committee. Who knows, right? The possibilities are endless because there is no one requirement. For example, in a condominium, there isn't going to be an architectural control committee because the condominium building is already built out, right? So owners don't have the ability to put anything on the common area, on the exterior, on the roof, or anything of that nature, right? They have to, they have no approval rights, right? They're not going to submit an application to put a high definition TV satellite dish on top of a condominium building. That just doesn't happen. It doesn't work that way. So I'm going to throw this out there, and some of you may ask some questions about this, but what if the declaration doesn't say anything about having an architectural review committee and you're in a planned community? What if it doesn't say anything about it? Well, we know what? We know that the board can function and make all the decisions of the association minus those reserved for the members. So if there is no architectural review committee created in the governing documents, the board could create one, just like they could create any other committee. And they can do what? They can delegate some of their authority that they have to that committee, just like they would to a nominations committee, just like they would to a landscaping committee, just like they would to an architectural review committee, right? And so what would you do as a board? You'd create a charter, which would set forth how many members you're going to have, what's the name of the committee, and what are its functions. And most of the time, those committees are going to answer directly to who? To the board, right? They're going to have to either make recommendations, but they're not going to make ultimate decisions. The board will be the one making the decisions. Now, I put down here, right, is there an appeal process? So in North Carolina, we have this fun creature of law called the adjudicatory panel. So what is an adjudicatory panel? An adjudicatory panel is a group of non-board members, they're essentially a committee, that functions as the first layer of approval for either violations or for architectural approval. And if you have one of these adjudicatory panels, the key is you're not allowed to have any board members on it, and there's an automatic right of appeal to the board if you get an unfavorable decision. Now keep in mind, the right to appeal is personal and specific to the person who received either the violation or received a negative response to their application for an architectural improvement, okay? And so the reason no board member can be on that is because it has to be a case of first impression. You don't want the same people voting on that voted to turn down an application, hearing whether or not it should be reversed, right? And so it's very similar to the way our court system works. So the fourth and final leg that we've talked about, right, just initially is those that are a challenge for the association to enforce. And so there's a very famous Supreme Court case that, it's with Larry Flint, right, and Hustler magazine, and the court could not define what pornography was. But one of the judges said, well, I know it when I see it, right? Well, that really doesn't work, okay? Because that's a very subjective standard, right? And so anything that's vague or that doesn't have a good definition is going to be really, really challenging to enforce, okay? And so the one place is there's not a good definition of it, or number two, there's no way to monitor it, okay? And so a couple of things we've seen in the architectural genre are these vague standards like, we shall maintain a coastal low country feel. Everything must be done first class construction, workmanlike conditions, right? Custom homes versus track built homes, things of that nature, okay? These are all, hopefully some of you are laughing out there, because if I were doing this in person, I might be doing some impressions of the types of communities that we have, right? But these are real things that I've pulled out of covenants, okay? When someone asks me and says, well, Adam, that's a violation because that's not coastal low country. Well, what is coastal low country? And the answer is, I know it when I see it. No court's going to uphold that. It's going to be very difficult to enforce, right? And so you got to be careful about that. How about this, though? Here's another thing that we see often, which is activity that people do inside the dwelling or that may be visible from the outside. During this political season, there's a great number of folks that try to skirt prohibitions or regulations on political signs by placing political signs or flags in their windows, right? So that even though it's not on their lot or it's not on common area, they're still able to display it, and they think they're getting around the regulation. And they may or may not be, right? We'll talk about that a little bit more later on. But the one that we see the most is usually the color of the blinds or the color of the curtains, things like that, when you live in a multifamily situation, such as a townhome or a condominium, where you want a uniform look and feel, okay? And so that's, it could be allowed in the declaration, right? We're going to start at the top. You may have the ability to do it, but you may not, right? And so the biggest thing, right, is when it comes to multifamily living is I'll get a call that says, hey, Adam, the owner refuses to give us a key to get into their unit, and we need to inspect their deck because we're responsible for maintaining it. We've adopted a rule that says that they have to give us their key. And I'll look at the declaration, and the declaration will simply say that owners, after reasonable notice and during regular business hours, have to allow access for the association to their unit to inspect common areas, limited common elements, that's very different than saying someone has to give you a key or has to give you a key code, right? So that's not a violation, number one, of the governing documents. So number two, we don't have the right to adopt that rule. So we need to be very careful about that. All right. So common challenges that associations face and kind of some outside the box solutions, right? What is the biggest one that we see, right? It's somebody is building without approval, right? That's a big one. Somebody starts construction of something without ARC approval or without board approval, right? And so, yeah, the association could spend a bunch of money on a lawyer like me and we'll file a lawsuit and get an injunction and we'll stop them, right? At a huge cost. But the first question you have to ask yourself is, okay, well, I don't like that they didn't follow the rules, right? That they didn't submit an application and they just built their shed or their dog run or whatever else. So the first question is, would you have approved it had they applied for it, right? That's what you need to think about as your board or your ARC, right? Because maybe you would have, right? So what are you mad about? You're mad because they didn't get approval. Okay, well, make them submit the application. And then if you would have approved it, then approve it anyway, right? Another common thing we see is that when somebody's fence gets knocked down in a hurricane, or maybe they need to paint their front door, things like that, they just go ahead and do it without permission. But they do it basically identically to the way that it was before. They put it back, right? Is that something they have to apply for or not? Well, your documents are going to dictate that, right? Another one is a time limit on approval. So a lot of governing documents that we run into will say that if the Architecture Review Committee or the board fails to make a decision on an architectural application within 30 days, that it's automatically approved, right? And so what happens if the association forgets about it? It gets under a sheet of paper and they forget that, no, we don't, we just approved something that should not have been approved, right? Well, you're kind of in a bind, but in a situation like that, you need to approach the owner and say, hey, look, we'll pay to remove it, or we'll pay to screen it, or we'll pay some, because, you know, the association screwed up, but you have to pay attention to that stuff, right? The other thing that you can run into kind of a gotcha is where developers, and they do this all the time, exempt themselves from certain restrictions, especially sign restrictions, or exempt them from architecture review process, things of that nature. And then they'll go ahead and delegate that authority to builders, right, that buy vacant lots. And so you need to be careful about that as to what the documents say and whether or not anything was recorded. Because typically a transfer of developer authority needs to be recorded, right? And so you need to see who has it. When I draft my documents for the developers we represent, I will let the board transition way before I let the Architecture Review Committee transition, because I don't want a member elected board messing with my client's ability to build and sell homes, right? So it's pretty typical. Some other examples, which can get a little dicey, especially down here on the coast, right, is these maximum built upon area, we call them BUA limitations. And the reason I say it's a problem down here at the coast is that we have a lot of stormwater regulations for runoff. And if you build a big home, there's a lot of surface area that the rain's gonna, and the stormwater is gonna, it's gotta go somewhere, right? And so we sometimes find associations getting into the role of the cop, right? They want to be like the governmental agency, but our advice is don't. if somebody violated a stormwater permit or somebody violated a county building code or a zoning ordinance, go ahead and report them or use it as leverage. Don't waste association money on that. Let the government agency do it for you. It's not your place, but we see it a lot. When it comes to arguments over style and color, right, be careful about that coastal low country feel or, you know, Appalachian feel. However, whatever these vague terms are, right, we see that a lot. Unless the color is really offensive or the style is really off the wall, don't waste your time trying to fight with somebody. I remember I had a president of a homeowners association that was a huge Florida State fan, and one of the owners in the neighborhood painted their door orange, and the president thought it resembled Florida Gators color too closely and wanted to get rid of it. And then come to find out the owner was a Gators fan. Well, you can see where that ended, right? You know, between a Florida State and the University of Florida fans, probably the same as it would between a Chapel Hill and an NC State or an ECU fan, right? And so there's no reason to get into that mix. Another problem that we see often is where the Architecture Review Committee doesn't want to make a decision, so they kind of try to punt it to the association, to the board, right? Can't do that. You got to follow the documents, right? Either the association has the ability through the board or through the ARC, but you have to follow the process. And then we've already talked about failing to publish to the membership. That's an easy trap, okay? So I get all the time, and I'm sure there'll be some questions tonight, like concerns about precedent. Precedent can be a thing, just like grandfathering, but normally your governing documents have a savings clause in them, which says failure to enforce this, or just because you approved it one time, it doesn't mean that you have to approve it every other time, right? When you have selective enforcement, we talked about at the very beginning, make sure you're adopting the rules properly. You have the authority to do it. You've got the proper procedure, right? And so when it comes to selective enforcement, that's like anything with the rules, right? And during this political season, for example, if you just wanted to go after people that had Biden signs versus people that had Trump signs or whatever, you're going to have to treat everybody the same when it comes to political signs. And we're going to get to that coming up here real quick, what they are and how and you can regulate them and so on and so forth. So just be careful when you're treating people differently or different portions of the community. You need to be careful about it, right? Finally, the one I want to talk about is when the new owner takes over a non-compliant property, right? Let's say somebody built a shed and they shouldn't have. Let's say sheds aren't allowed. Well, okay, but the person sells it before you can notice them for a violation. Now is the person who bought the home, are they in violation even though they didn't build it? You have to look at the specific language of your declaration, because it might say that it's a violation to build it, but if they didn't build it, then they're not in violation, right? So you have to be very careful about what the words say when it comes to non-compliant property. So the final, before we move to the political sign thrust here, is things to remember. Any rule or architectural guideline, right, is it practically enforceable? I like to ask that question first, right? Can we even enforce it? Do we have the ability to do it, right? It's kind of like speed limit signs on private roads. Those aren't speed limits. Those are rules. And if you don't have radar guns and you don't have speed bumps, you don't have other things, how are you going to make sure people slow down? You can't, right? It's very challenging to do that. Did the association have the ability to adopt the rule? Is it consistent with the character of the community? Who makes the decision, and how do they make it? And then finally, be reasonable, okay? That's the most important piece about this, right? Is these are folks are our neighbors, and we want to treat them politely. We want to treat them consistently, and we want to treat them fairly, right, with regards to the consistency of the documents. All right, so political signs here, kind of finish up on this. So what is a political sign? A political sign is considered anything that shows support in favor or against a candidate or an issue that voters will vote upon. So a political sign is not limited to a sign, right? Like in my little picture. It's not just a sign. A flag can become a political sign. It's near Halloween season, right? Harvest time. A scarecrow can become a political sign. A mannequin can become a political sign. A garage door can become a political sign, okay? Anything that is garnering support for or opposition against a particular candidate, trying to sway someone to vote a certain way, right? That is a political sign. So it's not just this, traditional sign that you think you'd put in your front yard. It could be a host of anything. So it's a very broad definition, okay? And most of the time what we see are flags or portions of people's homes. But right now, this is a very hotly contested political season. And there's folks on both sides of the aisle and both sides of, issues that are very passionate and zealous, and they're not afraid to show that passion, right? And so we need to be careful. We need to make sure that if they're allowed to do it, they're doing it within the bounds of our regulations. So in North Carolina, the first thing we have to determine when we talk about your ability to regulate political signs is, when was your community founded? Okay. When were you created? So I'm going to start with older communities, and these could be condos, townhomes, these can be single family. But if you were formed prior to October 1, 2005, in order for you to prohibit political signs in your community or regulate them beyond what the state statute says, it would actually have to say in your documents, in your declaration, that you have the ability to regulate political signs. Just saying that you have the ability to regulate signs is not enough to regulate political signs. Now, after October 1, 2005, for the newer communities, and it's funny, right? Because these are communities 15 years or younger, the first page of the declaration has to be printed in all caps, bold text. This document prohibits or limits political signs. And then you have to actually have the verbiage political signs in the document itself, okay? And so if those requirements are met for older communities and newer communities, then you follow your governing documents, okay? Which might be an outright prohibition, okay? But if not, if you're not in compliance, then no recorded restrictions. North Carolina law allows you, the board, to promulgate a rule prohibiting political signs, the display 45 days prior to the election, which is what we're in right now, and to not let them be out there more than 7 days after the election. And you can regulate the size, the number, and the limitation is that you can't prohibit anything. It can't be any more than 24 by 24. 24 inches by 24 inches, right? That's a standard size sign anyhow. But these can't be more restrictive than a local political sign ordinance, right? So, for example, if you are, if you decide you want to adopt a rule that says, hey, you can have one political sign and it's 24 by 24, but the county says that you can have 3, then guess what? You're going to have 3. So you do have the ability to regulate it, even if it's not in your, but you can't prohibit it, right? You have to allow at least one sign and for that specific period of time, 45 days before the election, 7 days after.
A couple of questions coming in, and so everybody feel free to ask your questions through the Q&A icon at the bottom. But one of the questions, how specific is too specific when you get into your rules, when your architectural guidelines, or at least your documents, give you a lot of leeway? And I'll tell you, I was working with a community yesterday, and I think I have a board member on the call, where they were discussing the lumens of a light and how many lumens should we allow within a community. Is any guidance on that?
Okay, so when we talk about the brightness of lights, right, lumens, as Ben has just mentioned, right, let's first ask this question, right, is that in the architectural purview or not, right? Is an aesthetic piece. It's probably not something the Architecture Review Committee should get into, right, but the board might be able to, because what is light if it's too bright? It becomes a nuisance, right? So I think the board does have probably a wide latitude to figure out what, what quantity of light would constitute a nuisance. And I think that as long as they can base it in good science, right, or typical lighting for like floodlights and things that people want for security, as long as it's not keeping up their neighbors, I think you could put it in there, right? But you have to be able to explain why it is you picked that number, right? Why is it reasonable? And, oh, well, that's a standard contractor, or that's industry standard, right? And so I think you're okay with doing that. That's not too specific, as long as it's based on something reasonable.
Okay. So you mentioned condominiums and the common elements, and it's something that ARCs do not exist necessarily, or committees do not exist in condominiums. But there are limited common elements within the community. How does a board or a committee handle reviews on limited common elements?
So great question, right? And so what is a limited common element? It is a smaller subset of a common element which has been specifically attached to that particular unit, right? For exclusive use by that unit owner. So down here, right, down on the coast where I am most of the time, we have a lot of condos that are on the beach. And they have lots of rules about do not hang wet beach towels on the railings, right? Because limited common elements are a subset of common elements, the board can adopt rules and regulations regarding what folks can keep on their decks, on the limited common elements, right, on their railings, things of that nature, right? So they prohibit barbecue grills, they can prohibit signs, for example, because it's within the purview of the common area.
Okay. Let me see. The ambiguity, when you're dealing with properly maintained or unsightly, and you mentioned nuisance. So can architectural rules be used to help define the vague and ambiguous type language?
I don't like to mix my regular rules, right, like a nuisance or noxious or offensive, with my architectural guidelines, right? Because what are architectural guidelines supposed to be? They're supposed to be based on aesthetics, right? And so you either are in compliance or you're not. There's no gray area when it comes to architectural, right? Either your house is too high, right? If it says 2.5 stories. So to me, I'm just going to put it to you guys this way, right? If you don't have a definition of what nuisance is or what offensive behavior is or things of that nature in your documents, which most don't, the board can sit there and adopt what a definition they would like to use. But I'll tell you what's funny is the courts, they're going to go to Webster's dictionary. They're going to look at what they call the ordinary commonplace meaning of it to figure out what the definition is. So my advice, Ben, would be that if you want to be specific, then you really ought to amend your documents to create that specificity that you're looking for about definitions, because otherwise you're taking an awful chance if you push comes to shove, because courts don't like it when boards are subjective and when different boards interpret things differently, right? They like it to be consistent.
So what about signs in public right-of-ways? So if it's in between the sidewalk and the curb, now this may be a lot owner's property, or it could be common property, but is there a difference between, when you're dealing with public right-of-way?
All right, so we'll talk about two things, right? In a private community, right, where you have private roads, private right-of-ways, what Ben is hinting at is that a lot of times you'll have a 60-foot right-of-way, but the road is only 30 feet wide, right? So really what people believe to be the first 15 feet of their yard being their yard from the road to their home, it's not. It's really owned by the association as common area, even though the lot owner maintains it. So the board, right, can make rules about what can be in that particular area, right? And so if you put a sign in there or do anything in there, the association can come and take it. So I'm sorry, I don't know what happened there, but I was talking about right-of-ways. So I know you can't see me, but if you can hear me, we were talking about public right-of-ways, and I talked about a private community. In a public right-of-way, right, that is a public street or a right-of-way, go ahead and you can just call the municipality, okay, to come and remove that sign or get it out of there. I'm going to give you an example. Had a community recently that there was a UPS driver that was retiring, and everybody loved this UPS driver, but they all got signs in the neighborhood and put all these signs along the street saying, hey, thanks, Kevin, for 30 years of service. Well, guess what? Somebody in the community didn't like Kevin. They called the city of Wilmington, and they brought a public works truck and collected like 300 signs, okay? So that is, that's a reality that can happen with that. Again, only adopt rules over property that you have control over.
Okay, so clarifying something that you had said previously, Adam. So if our community was founded prior to 2005 and our governing docs say signs or no signs, period, can someone still have political signs for 45 days ahead and 7 days after?
Yes, that is correct. Because if you are a October 1, 2005, and your declaration just says that we can limit and prohibit signs and doesn't say you can prohibit or limit political signs, then folks are going to get at least one political sign 45 days before the election up to 7 days after, because your document is not consistent with what the law says it has to be for specificity.
Okay. Political time or signage is time sensitive. Many of the times violations is moot by the time a warning, hearing, and fine is imposed. Can the 10-day warning period or the cycle be shortened? So this gets more into the fine process or the hearing process. It might be another lecture.
No, it's a great question, right? Because as a best practice, we typically recommend to all of our communities that you give at least a 10 days written notice, right? So in a political season, let's say somebody pops up, they've got 3 extra signs. You send them a notice, they have 10 days. They bring them in for the hearing, they say, you're unconstitutional. I'm gonna do what I want, right? And so then what do? You have to give them 5 days grace period to remove them. So now you're at 15 days, right? And so what we typically recommend is 10 days as a best practice, but during political season, we'll sometimes say, shorten it down, maybe 5 days. Don't go any less than 5 days, but kind of shorten it down. And we also treat, if someone, it gets cute, right? And at the beginning of political season, they pluck their extra signs, or they pluck their sign and then they put it back. We consider that a continuing ongoing violation. So we don't hold a new hearing for that. We just say, look, you violated, you knew it, you removed the sign. Now, if you stick it back, you're getting fined $100 a day. And so we will shorten it and most people are pretty compliant. They're not going to fight it because the law is not settled 100% that it has to be 10 days. We just know that 10 days is best practice and defensible. But as long as the law calls it reasonable, and I think during political season, 5 days is reasonable.
So if you have a rule that says only for sale signs are allowed based on what's going on today, is there any danger of violating free speech or preventing political signs?
Two things to talk about. Number one, when it comes to the First Amendment, right, which folks say that I have a right of free speech, that only exists with respect to government regulation, okay? An association is not a government entity, so therefore, it cannot be unconstitutional or a regulation of your free speech or someone in a private community HOA to regulate it, right? So that's a terrible argument that people, right? But if your covenants say you're only allowed to have for signs, but they don't say including no political signs, well then guess what? You have to allow political signs. So if you don't, so the lesson here, guys, is that if you don't want political signs to be in your community, you want to get rid of them altogether, or you want to regulate them in a way that's different than the statute lets you, you need to amend your declaration to specifically carve out political signs. I don't care when you were formed, 2005 or after, because otherwise that type of language is not going to get it done for you.
So in your opinion, is a Confederate flag considered a political sign?
I think that a Confederate flag could be considered a political sign depending upon the timing of when it's displayed, okay? Just like I think a Black Lives Matter sign could be considered a political sign depending on when it's displayed, right? Because it's in support of a candidate or in support of an issue or against an issue, right? Now, the way we deal with a Confederate flag, typically the way we deal with it is that it's not a U.S. flag and it's not a flag of the state of North Carolina, so an association can totally ban that flag because there's different rules about it. So you don't even need to call it a nuisance, but any flag that's not a U.S. flag, a current U.S. flag, or, you know, they call the colonial flag, right, with the 13 stars in a circle, or a state of North Carolina, current North Carolina state flag, then you can just ban the flag. So you don't even need to get into the political sign debate.
Okay. You spoke earlier about the adjudicatory committee. What are the pros and cons of including non-residents on the committee? Wow,
that's a big one. Okay, so first off, you need to make sure that your governing documents allow you to have non-members or non-residents on the committee, right? There's a lot of requirements in governing documents that say to be a director or to be an officer or to be a committee member, you have to be an owner or a member. If they don't say that, number one, I don't know any non-community member, non-developer appointee that would ever want to serve on a homeowner association committee, right? So, but pros and cons, here's the thing. It's an unpaid position. You want to make sure that you have your director and officer liability insurance covering your committee members. That's first thing first. But having a non-community member might be beneficial if you're allowed to have it, because they can be totally objective, right? Because they have no personal attachment to it. But the second side of that, or the double-edged sword on that, is that they don't have a vested interest in the community, so they really don't care what the people in the community want, right? And so I think it depends on the person. I don't think, it's just like folks like to tell me all the time that tenants are bad and they don't pick up their pets' waste. Owners will, but tenants won't, right? Because they're tenants, they're bad. Well, I don't like to focus on who it is. I like to focus on the behavior I'm trying to regulate. So if you've got a good person, right? I've got associations that hire architects and engineers that don't live in the community to serve on their ARC. I love it. I love it because they're professionals covered by their errors and omissions, and they're gonna look at that application and know better than a layperson whether or not it's compliant with the documents.
Okay. So for a board or ARC that wants to require a proof of proper permits from the city or town that have been attained, do you recommend that being something that the HOA or the board should be involved with, or is that on the owner to handle?
Oh, I wish you could see my face for this one. No, listen, the association should not be involved in that at all. That's not your sandbox. Don't play in it. I have associations that try to get the building code enforcement division to give them a heads up about stuff when applications and permits are pulled. Don't play that game. Stick within the four corners of your documents. You're just, what you're doing is you're setting yourself up to potentially be sued for tortious interference with contract. You do not want to do that.
So do boards have the authority or need to review interior renovations in a unit of a condominium that would be similar to the ARC process?
I think that when you talk about multifamily living and housing, the documents are going to be specific about what folks can and can do inside their unit. And a lot of times, the association acting through the board will have authority to decide what kind of floor coverings, for example, you can put in, right? Because you don't want hardwood or you don't want ceramic tile because it's loud for the owner that's beneath the person who's changing their floor out. Now, ground floor is totally different, right? But yes, I think there can be some utility in terms of what folks are putting in because it goes to the communal nature of it if somebody installs something that's going to cause a problem for someone else. So most condo documents will allow some type of control over installations on the interior, especially if they're going to be attached to the common elements, right? The common areas, the limited common elements, to be able to inspect it and approve it.
Okay, we have a couple of questions regarding South Carolina and political signs, and I don't know if you want to answer those questions or how you'd like to address that, but shall I ask them?
Yeah, I'll just say I know nothing about the regulation of political signs in South Carolina. I know that the property acts that are in South Carolina don't really touch on them. So I apologize, Ben. I just don't have the depth on that one.
Okay. Let me see. I'm going to ask two questions. We're a little over on time. So let me make sure. Can you ask about vague political signs not stating a specific candidate? So, so the BLM signs, the thin blue line signs, thin red lines, how are those treated? Are they political or are they something else?
Right. So I think that a lot of the context of the sign and the display of the sign determines whether it's political. If not, then it's just a sign, right? And then we regulate it as though it would be any other sign, right? And so if we say it's not a political sign, then we're under the big catch-all of no sign can be put up without permission. But I'll give you an example, right? I have a community where a woman has had a Blue Lives Matter flag for 3 years since her son was killed in the line of duty, okay? That has not been viewed as a political sign, and they've allowed her to have that flag. I've got another community where some Black Lives Matter signs popped up and then some Blue Lives Matter signs popped up in response, right? That's a clear indication of context that this is now political and is no longer just a sign anymore, right? And so I think that you need to talk to your attorney and get some facts behind it, the timing of when it's put up. I think now during this political season, I think pretty much I will do my level best to determine something falls into the political sign category, including scarecrows that say BYEDON, right? So it's by done, right? But it's like by dawn, right? And people are like, well, that's not political. Well, yeah, it is. Those are political signs. Those scarecrows need to go, right? Take the sign off the scarecrow and leave it as a scarecrow. So then what do? They put a giant orange wig on it and a red tie. Okay, is that a political sign? Yes, I think so, right? So, you know, and anyway, I hope that answers that person's question, but it's you got to ask your representative attorney.
Okay, now the last question, and this is not political, but if a community has lighting installed throughout for safety and security, does a homeowner who is offended by a light shining in his home have the right to have Duke Energy turn off that fixture and shield it?
Oh, I love this question. This is awesome. First of all, those of you that have seen me speak, I do a session on safety and security, and it's basically an hour long on telling you why an association is not the arbiter of safety or security for the members of your community, right? It's not an area that you should be jumping into. Associations need to maintain and protect their assets, not the individual assets of the owners or the owners' persons themselves. So I disagree with the idea of installing these lights. However, if these are street lights or these are, right, lights can be a nuisance. We've already talked about that, right? So I think the person has, if they have a private right of nuisance, they could call up Duke Energy and ask for some shielding or ask for some privacy with respect to the light shining into their home.
I do appreciate your time today, Adam, and thank you for everyone that attended. We are doing these monthly, so please be on the lookout for our next session, which will be held, I think, the third Thursday of the month. So we do look forward to everyone attending, and we will be sending out surveys following the presentation. So thank you again for your time.